Welcome to JGL Law for You. This podcast is sponsored by Greenwald and Laake, a suburban Maryland law firm that has been representing clients throughout the D.C. metropolitan area and across the country for close to 50 years. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will bring you up close and personal with our lawyers and some special guests who will be discussing how to navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. We are kicking off our third season of JGL Law for You. And to start this season, we have a really timely and interesting topic, police reform in the state of Maryland in the wake of COVID-19 and the murder of George Floyd. Today, we have two guests to discuss this topic with us. The first is Alan Liu. Alan is policy counsel in the Legal Defense Fund's Justice and Public Safety Project, focusing on the criminal legal system and policing reform. LDF's JPP advocates both nationally and locally for reimagining public safety. This past year, the Legal Defense Fund worked closely with advocates in Maryland to pass key police accountability measures. We also have from Greenwald and Laake, Hannah Nallo, who is an associate in our litigation practice group. Prior to joining JGL, Hannah clerked at D.C. Superior Court for Judges Michael O'Keefe and Jose Lopez, both of whom presided over a felony and civil docket. Through these experiences, Hannah was able to witness the criminal justice system firsthand and see the effects of policing in the DMV. She has a passion for litigation and for representing clients who are the victims of police misconduct. Alan and Hannah, thank you so much for joining us today. Looking forward to this discussion.
Thank you for having us, David.
Thanks so much.
Let's start out, you two, with what exactly is the Maryland Police Accountability Act of 2021. Can you fill us in on what that law is?
Yeah, so I could take that one.
Sure.
The Maryland Police Accountability Act of 2021 was a huge bill that the Maryland legislature took up in the wake of the George Floyd protests to try to get some key police reform in Maryland that people had been calling for all year. And Maryland really is leading the way in these reforms in a lot of key areas that Alan and I are planning to cover today.
All right. Tell us a little bit about what the law involves, A, and B, what brought it about? I understand the politics and I understand what happened with George Floyd and so forth, but can you drill down a little deeper for our listeners in terms of what brought that law to the Maryland floor and what does it do for our citizens here in Maryland?
Yep. So I can take the first part about, what are really the key measures that we see as part of this bill. The first is the Maryland Police Accountability Act. It really repealed a lot of barriers to accountability in the police disciplinary process. And part of that was repealing the Law Enforcement Officers' Bill of Rights and replacing that with new language. And I'll dig in a little deeper later about what is the Law Enforcement Officers' Bill of Rights, why it exists, why it was repealed. And Maryland was really the first to establish the Law Enforcement Officer Bill of Rights and the first to repeal it. The second thing that the bill did was increase the civil liability limit on lawsuits in Maryland involving police officers. So you can sue your local government for police misconduct, but you can only civilly recover $400,000. And so this bill upped that cap to $890,000.
All right.
And the last key measure is there's a new procedure which gives civilians a role in the process for disciplining police officers.
All right. So let's go back if we can, Alan. I want to bring you in here. And let's start with what is the Law Enforcement Officers' Bill of Rights, what it did for police officers, and why it was there to begin with. And then if you'd move, and I hate to give you multiple questions in one, but then from there, why did it need to be changed?
Great. The Law Enforcement Bill of Rights was actually first passed by Maryland. It was the first in the country to pass in the 1970s. And since then, a number of states have followed suit. It happens that, as Hannah mentioned, it's also the first state in this past session to repeal it. What its intention was to establish certain rights for officers during the disciplinary procedures for misconduct, for alleged misconduct. These laws are controversial because in many instances they prevent accountability and transparency in police work.
Give us an example so that we understand when you talk about accountability and transparency, what are you talking about? If you can, something simple that we all can follow.
Sure. So these rights and protections are those that don't exist for any other civil servant. For example, if you and I were serving for a city council and we were alleged to have conducted misconduct in our official capacities, the investigation into our misconduct, alleged misconduct, would begin quite immediately, I would think. For police officers, the Law Enforcement Bill of Rights, short is LEOBOR, they prohibited the investigation from beginning for, in some instances, for 2 days, for example. So it would provide officers time to review recordings, get their story straight. In some instances, it would potentially present the opportunity for officers to belie the truth and ultimately prevent measures of accountability that the public is due.
All right. So there was this 2-day sort of waiting period, right, where this complaint, Mr. Jones makes a complaint against Officer Smith, and Mr. Jones' complaint for whatever the misconduct is alleged would basically sit on a shelf for 48 hours. Is that what you're saying?
Yeah, and investigators, internal affairs officers wouldn't be able to interview the officer alleged to have conducted that misconduct for those 48 hours. It would allow opportunity for that officer to consult with counsel, which is appropriate, but those protections are not afforded to any other civil servant in public.
So let me ask you another question as a follow-up to that for either of you to answer. And probably neither of you were born at the time when the law was written and made law. But why was that provision there to begin with? Why was it right then but not right now?
I think that's a great question, and I'm not exactly sure of the answer, having not been born. And, it's always easier to look at history in hindsight.
All right.
But, I think it was part of just a small part of other due process rights that the LEOBR was trying to implement for officers, right? So along with the waiting period, it was also, the LEOBR prevented civilians from being on these review boards, and they allowed officers to expunge part of their misconduct records. So, there's other things tied in there. It wasn't just the waiting periods. There was a whole slew of measures that I imagine I'd give people the benefit of the doubt that the intent was really to give more due process rights to officers, and the actual result of those intentions turned out to be that there was less accountability when misconduct occurred and just less transparency.
The old unintended consequences rule, I guess, is what you're referring to, right?
That would be my argument, yes.
Okay.
I think it's an important question to ask, what was the historical context that led to the passage of LEOBOR in Maryland to begin with? And in the 60s, as we know, it was the heyday of the civil rights movement, protests across the country on college campuses and cities and suburbs. Folks were coming out and saying that we needed to build a more perfect union for everyone. And in response, we saw in many places, for example, in Chicago in 1968 and in cities all across the country, really in the 60s and early 70s, we saw a heavy police response to largely peaceful protests. And I think that the rhetoric around that time with regard to law and order contributed to the notion that we needed to expedite justice. And justice in that case meant these communists outside of society, people and parties should be done away with. And I think that may have contributed to these laws that provide these elevated protections for police officers.
I wonder, without jumping too far over the wrong side here, is there an underlying racism in that law? In other words, if you look back at the riots of the 60s and then leading through the Vietnam War and thereafter, it often was white police officers and people of color who you saw, although certainly in the Vietnam protests, it was across the board, but during the civil rights protests in the 60s, it was often people of color who were protesting, whereas it was often white officers. Was there any of that back when this law was enacted initially? And we know it's been repealed, but you think there was any of that underlying back in at that time?
Yeah, and that's also a great question. Academics as well as folks who have experienced this for decades will tell you that the relationship between law enforcement and race is inextricably linked here in this country. Since its inception, its purpose was to catch slaves, and it has morphed into a system that disproportionately criminalizes Black people and Black communities.
So, all right. So let's toggle down to this damages issue for the civil liability piece. Tell us about, where that came from, why it was raised, and also it seems like an odd number to me. Why 890,000?
Right. So first I'll explain the civil liability really came to play in Maryland because people would go to sue their local government for police misconduct, and they would get these huge jury verdicts of millions of dollars. And as soon as they got their verdicts, the court would have to bump any recovery that they were awarded down to $400,000, which many people thought was unfair, justifiably, to think you're getting millions of dollars as an outcome, and then to go to less than $500,000 is a huge jump. So part of the bill more than doubled that number. So it went from 400,000 to 890,000 for a local government's liability. And I will mention just on top of that, on the criminal side, an officer could face 10 years in prison for causing serious injury or death for unlawful use of force. So there was both a change in the civil penalties and the criminal penalties for police misconduct.
And so that we're clear, the civil penalty isn't paid by the officer whose misconduct is alleged, right? They're paid by that particular governmental agency for whom he or she is employed, right?
Correct. Yes.
And that money, therefore, comes from taxpayer dollars.
Yes, it does.
And I'm going to assume, and tell me a little bit about this, that is something that went into the discussion when this most recent law was passed, right? I mean, you got to have some people say that's too much, right?
Of course, there's always.
So how did that get handled? How did that get handled by the folks who were the proponents, Alan, of this law?
I'm not directly familiar with how this piece was handled, but my impression is that it serves as an accountability measure. Folks who I believe argued for this would say that, there are not enough barriers to misconduct, right? There are protections to accountability and transparency, and the cap for civil liability is just not enough sting to prevent officers from
acting badly or doing something they shouldn't do, I assume.
Right.
I mean, in the big picture. Is it the thinking that if we raise the amount of money that the employer, i.e. the governmental entity, so if it's Montgomery County Police, they work for the Montgomery County, and if there's a judgment against an officer, the county pays that judgment if it's during the course of his or her duties, right? So isn't the intent to force the employer, in that particular case, the county, to do a better job of hiring and training its police officers?
Yes, I think that that's really the intent, is to get the county to feel that there's an incentive for them to change their training practices, change their hiring practices, to be more strict with who they're hiring to be police and doing background investigations to make sure, okay, we have the best possible people out there as police officers doing the best job that they possibly can, so that, we don't have to keep paying out these huge settlements and, making news every single time. That's not what they want to have happen either.
And you indicated that the new procedure gives civilians, in other words, non-county employees, non-police folks, some role in the process, in the disciplinary process. How does that work?
I think I'll let Alan take this one because he's the best at really explaining. There's a 3-tiered process now and 3 different avenues that civilians can actually be involved in the disciplinary process of police officers.
Hannah, you're too kind. So the new disciplinary process is quite involved. The way that I look at it is that there are tiers for accountability. The first is the police accountability boards, who are selected by the governing body of each jurisdiction. Their purpose is manifold. It includes reviewing police policies, disciplinary processes. Its purpose is to take a look at how accountability and transparency works in that jurisdiction, and to work with the community and police, the law enforcement agencies there, to make it better for everyone. They also select members to the administrative charging committee. So that's the second tier of and how I picture the second tier. Their purpose is to process misconduct allegations. When these complaints are filed, they are forwarded from the police accountability boards to the administrative charging agency, which conducts the investigation. That charging committee is tasked to complete the investigation, provide a report, and a recommendation for discipline. And then once that process completes, that report and recommendation is forwarded to the trial board. And the trial board is the body that consists of a judge, a civilian, and a police officer. That body is tasked with actually conducting the hearing of whether or not the officer should be disciplined.
All right. So say you're just an average Joe citizen, and I want to get involved. I want to serve on this panel or a panel, or I want to be involved in looking at this, both because for whatever reasons, one is I've got an interest in it, or maybe I'm interested in there being fairness between the new laws and fairness to police officers. Who would I contact, or how would I get involved?
And so that's a great question. And Alan and I have talked about this because it's really not included in the statute as it reads right now. And the limits of what they put in the statute is that the membership of these boards, it just has to reflect the community to the extent practicable. But it doesn't say how the local government should go about selecting who the civilians are, what their qualifications should be, what their background should look like. So it's really about getting in touch with your local government, seeing how they are interpreting this statute, how they are selecting the civilians who will be part of these boards, and seeing if you can follow up to get involved.
Okay, but there's no process. It sounds like that the state statute is leaving it to local governments in order to figure out how they want to effectuate the new law and involve citizens.
Correct. The state statute basically mandated that each county create these committees and boards, but they did not mandate how the counties would go about really executing those boards and committees. The one thing I would add to what Alan explained is that, in the administrative charging committee, really where they start making the recommendations for discipline, they allow the chief of police to discipline an officer within 15 days of them being charged. And, the officer can accept the discipline at any time. And it's really only when the officer rejects the discipline or challenges the discipline that the matter gets referred on to the trial board. So it doesn't always end up in the trial board phase. And I will say also that officers are allowed to appeal the trial board. So they can go to the county circuit court, which is really Maryland's, state level trial court, to appeal any of these disciplinary decisions.
So Hannah, here in Maryland, and I don't want to toot our law firm's horn too much, but Joseph Greenwald and Laake was intricately involved in the passage of a new police-related law here in Maryland in the past year. Is that right?
That's correct. And fortunately, I'm lucky enough to work with Mr. Timothy Maloney, who is a titan in Maryland law. And he worked with the legislature to pass reforms for what's now being called Anton's Law. And part of that is that the public now gets access to officers' disciplinary records. And that is huge. And the reason that that is so large is that we can now get these records from police officers' misconduct and compare them and see them as really what is the pattern and practice of these police departments when it comes to use of force and other kinds of misconduct. And so that's going to have a really, really great effect on all these cases that we're going to have in the future.
It allows people to have access to information about police officers and things they may have done wrong prior to that particular incident, right?
Correct. Yes.
And that's access that they didn't have before.
Correct. Yes.
Well, I know Tim very well. I'm not sure Titan is the right word, but we'll let that pass for this particular broadcast. Now, when did this law pass, by the way? I want to toggle back just a second because I have a question to ask. Was it during the course of 2021, this past year?
Lawmakers in Maryland voted in April of 2021 to pass these bills, and they had to override Governor Larry Hogan's veto. So that happened in April.
All right. So what effect, if any, is the layering of COVID and the pandemic? What did that have in terms of the drafting of the law and the passage of the law?
Well, I'll let Alan take that one, but I imagine that I won't speculate. I'll let Alan take that one.
Speculate away. That's what we're here for. Go ahead, Alan.
Sure. So I think COVID, it brought to light the deep disparities in our country and in Maryland. The impacts of COVID were disparately felt on communities of color, Black communities, Black people, and the murder of George Floyd, brought that even further to light. And I think the two in tandem served as a call to actions for so many across the country and particularly Maryland to take to the streets, to call their local representatives and to call on their state representatives to do something about it. It was an involved process. Fortunately, advocates, victims, and their families were able to be involved in that process. But I think that these issues have existed in our country for decades, if not centuries. And the pandemic, as well as the murder of George Floyd, really brought that to light even more.
All right. Let me ask you a couple specifics about the law that struck me. The first is that it banned sentences of life in prison without the possibility of parole for juvenile offenders, right?
Yes, so that was a separate bill called the Juvenile Restoration Act.
Right.
And it allowed, on top of banning sentences of life in prison without the possibility of parole for juveniles, it actually also allows a minor who's sentenced as an adult and has served 20 years in prison to petition the court to get a reduction of their sentence, which is huge for juveniles who get sentenced as adults for crimes. And it doesn't limit what types of crimes they can petition for. So that ultimately is the court's decision for whether they've been rehabilitated while in prison. They take into account that juveniles' brain development is different than that of adults, and their decision-making processes are different than adults, and really sees, okay, is this person the same person that they were when they were a child and committing these crimes? And I will say, as someone who clerked in D.C., it's very similar to the D.C. statute that we worked on. In D.C., if you're under 25 at the time you committed a crime and served 15 years, you can petition. So,
does this apply to offenders prior to the law being passed as well, or does it just apply to those who are convicted subsequent to the passage of the law?
I believe it's retroactive. Alan would have to correct me on that.
Alan?
I don't know myself.
I mean, one would think it would be retroactive, I would think, but raised a question for me. And also, for someone who was around here during the sniper shootings, who lived their life worrying about going to get gas, and I know that Lee Malvo is certainly one of the people that have been discussed as part of this new legislation. It's a guy who rode around in a car randomly shooting people up and down throughout the Washington, D.C. suburbs, and we're going to give him the opportunity to get out? Why is that?
I think that people understandably are upset when they hear that people can make these petitions to the court. But I would make the argument that it is just that, it's a chance, and it's not a guarantee. It's not saying that we're going to start letting out violent offenders onto the streets who have not changed. It's saying we're going to take another look at your case because of the circumstances, because of, juveniles and the way their brains work. We're just going to give you another chance, another look at your case, another look at your file by a judge. And so, nothing is a guarantee. Nothing is saying that, just because you have this opportunity, you're now going to be released. I did look back. It is retroactive. So the
All
law
right.
is retroactive.
Well, that makes sense. And you did make a good point earlier. And as someone who's been married to a therapist for 35 years now, I'm well aware of the fact that juveniles, that our brains as human beings are not fully developed until roughly our mid-20s. Right. So there is some sense, it seems to be scientifically based, that you ought to take another look at what someone did when they were 12 or 13 or 15 or even 17 for that matter. Tell me about how the new regulation on the use of force is involved in this particular law.
Yeah, so the statute actually created a provision to regulate use of force by police officers. And this, to me, is huge because beforehand, this was a standard that was governed exclusively by case law. So the courts would interpret whether or not the use of force by an officer was appropriate based on prior cases that had looked at the language, right? So now we have an actual statute that the courts can use that has language about when use of force is appropriate. And so the way that it reads now is a police officer may not use force against a person unless, under the totality of the circumstances, the force is necessary and proportional to prevent an imminent threat of physical injury to a person or to effectuate a legitimate law enforcement objective. And so if you intentionally violate that statute and it results in physical injury or death, you have a criminal penalty that goes along with that statute now.
All right. So an unintentional violation is obviously not as bad as someone who is deemed to have intentionally violated that sort of guidepost that you just set forth.
Correct. And I think that's really the two limitations on this, is that it's for intentional violations and it's also only for serious physical injury or death. It's not for minor injuries.
Alan, let me ask you a question as we're starting to wrap things up here. Is there anything that you and your folks believe was left out of this particular statute and what you may still be working on to have the legislature add later?
Sure. And thanks for the question. I think it's important to frame the measures that were introduced last year as focused on accountability. These measures are prophylactic in that they are geared toward providing access to justice for victims. And I think it's important to look at this coming year through another lens, and that's through justice, right? So the first year, 2021 should be looked at through accountability lens. This year should be looked as a justice lens. And that means that we should try and prevent this harm from occurring in the first place. We should provide some measure of justice in the system to prevent these disparities from occurring. So in so doing, our thinking is that measures that should be introduced and passed this session include measures on school police, measures on qualified immunity, marijuana reform, independent investigations of force, the authority for the Attorney General to initiate pattern and practice investigations, and for increased accountability measures through data collection. And I'll just quickly go through them. I won't take up so much time with them, but with regard to school police, it's quite clear that police do not make schools safe, and it's quite the opposite. They make them less safe. Studies have shown that increasing counseling services and mental health services actually make students more successful. So funding should be redirected from police and schools to counselors and social workers in schools. And in so doing, Maryland would follow states such as Minnesota, Colorado, and Oregon. So to deep a little deeper, schools in Maryland are deeply underfunded and under-resourced. But the literature is clear. Police officers don't make schools safe. They, in fact, make them less safe, and they criminalize children, our youth, especially Black children. So national research demonstrates that there is no evidence that students of color misbehave more than their white peers, but students of color are often disproportionately disciplined for minor offenses like disobedience and disruptive behavior. And so in Maryland, for example, in the year 2018 through 19, there were 3,141 arrests made in schools, 84% of which were by school police. Of that percentage, Black students accounted for 56% of those school arrests, but only account for 34% of the state's school population. Whereas white students comprise of 37% of the students' population, but only 28% of those arrested. So there are disparities that exist in the enforcement of laws in schools. And to bring it home and to provide more context here, in 2016, a Baltimore school police officer was caught on video slapping and kicking a 16-year-old student. And that officer later pled guilty to 1 count of second-degree assault. And in another incident in PG County, a police officer punched and arrested a high school student. And that officer was convicted of a second-degree assault, misconduct in office, and reckless endangerment. And so what's the solution? The solution is that students should be provided resources to help them achieve in their setting. And that setting is in schools. And what do we do in schools? We educate, right? We try to help students socialize. And as we have learned during the pandemic, we try to provide a learning experience, but they also provide caretaking services for working families. And so research also shows that 72% of today's students experience at least one traumatic event before they turn 18. And that suicide rates amongst 10 to 17-year-olds have increased 70% between 2006 and 2016. And research also shows that students without social services on campus have lower graduation rates than those that do. And moreover, schools that employ more school-based mental health providers see improved attendance rates, improved academic achievement, career preparation, and graduation rates. School-based health services improve health outcomes, but they also improve school safety. In that same study, schools that employ more school-based mental health providers also saw lower rates of suspension, lower rates of disciplinary incidents, and lower rates of expulsion. And so it's clear what we need is not more police in schools. It is more counselors and service providers and wraparound services to actually give our students a chance to succeed in those settings.
Okay. We could probably have a full discussion about that, I imagine, from one side or the other. Probably been a lot of debate about that. Certainly in Montgomery County, I'm aware of, and other counties in the state. I want to ask you one other quick question before we close things down here, and that is we've spoken a lot about the state of Maryland. We just finished a political year and an election, difficult election in 2020, and with the president who was calling for federal reforms across the board. Is there any traction in terms of any federal legislation, not just in Maryland or the district or any other states for that matter? Is there any traction in terms of nationwide policing laws?
So I will say that there was a great traction earlier this year in the spring for passing police reform on a federal level. And President Joe Biden even called for lawmakers to pass a policing bill in his first joint address to Congress. And he asked them to pass it on the first anniversary of George Floyd's death, which would have been May 25th of 2020. And unfortunately, here we are, fall 2021. And in September, it just came out that talks have essentially broken down and that there is nothing, unfortunately, on the horizon for getting any kind of police reform on the federal level. And it seems to be that, one of the key sticking points is qualified immunity, and that, neither side can really make the essential compromises to pass on that issue. So unfortunately, there's nothing on the federal level, but I would say that Maryland is really leading the way when it comes to police reform.
I want to thank both of you, Alan and Hannah, for joining us today. If folks want to get a hold of you, quickly let them know what the best way is to do that. Alan, you first.
Sure. So you can get a hold of the NAACP Legal Defense Fund through our website. We're also on all of the social medias, pretty active on all of them, and we look forward to further engaging in Maryland.
Awesome. And Hannah, how would people get hold of you if they have a case or a question or anything else they'd like to discuss in this area?
Yep. So people can get in touch with me on the Joseph Greenwald and Laake website, and always available by phone or email. You can find it on the website.
What's that phone number, Hannah?
Our phone number is 301-220-2200.
There you go. Might as well give you a plug whenever we can. Thanks to everyone out there for listening, and we hope you join us for our next episode. I'm David Bullitt, and this is JGL Law for You.